right, let's go ahead and open.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, gum chewing, or reading any materials. Thank you.
Thank you. This is case number 24-1223. This is Christopher Kendall versus Peter Carter. The matter is before the court on an adjourned date regarding a motion to show cause. The court required the submission of a proof of service document in this matter. Do I have Kendall Christopher on this note?
Yes, Your Honor.
All right, thank you, Mr. Christopher. Mr. Christopher, I have received the the proof of service document, and it really is a proof of attempted service. The process server was not able to serve Mr. Carter, and so he submitted a document saying that he attempted to make service, and that is insufficient. But based upon his attempted service, sir, I am going to allow you now to serve the document by ordinary mail. So what you're going to have to do is you're going to have to send the document by ordinary mail, and I will allow that to be service regarding this matter. So what I'm going to need you to do you have your show cause? Do you have the show cause document with you in front of you, sir?
Not in front of me. I can get it out right now. I have sent him a piece of certified mail, and it came back as if he is no longer at that address.
I'm sure, but that's the last known address that you have. And so what you're going to want to do is just send it to ordinary mail. Send it to ordinary mail.
Okay.
What I'm going to do is I'm going to give you a new date. So when this document is sent out, in fact, what I'm going to do is this proof of service that you sent, did you fax this over? How did you send this document to the court?
The proof of service, I made copies and then gave them to Mr. Mobley.
Oh, no. I'm talking about, I have a copy of that today. How did you get that to me?
Oh, I sent them via email.
Okay. So what I'm going to do is I'm going to have my clerk to send you the motion and affidavit via email. It's going to have a different court date on it. So
okay.
When you receive it, what you want to do is you're going to take that document and put it in the mail and mail it, just ordinary mail, and it's going to have a particular court date on it. That date is going to be that date's going to be the 12th of June 12th at 9:30. All right, and send that to ordinary mail. Once you send it to ordinary mail, make sure that you take a copy or take the back of the form, that says proof of service. Make sure you have a copy of that. On the back of that form, you're going to put that I served by first class mail. You'll see the documents, you'll see the box, the check on. And then and then you want to sign that at the bottom, and that's what you want to send it to.
Okay, so I will take a copy of the back of the form for the proof of service, and I will bring that into the court once I've finished serving.
Exactly
and
right.
Say that I've served him by first class mail.
Exactly right. And you're allowed to serve by first class mail by special permission of the court because of the fact that the defendant has now responded to attempts to serve it. And so I'm allowing you to do what's called alternate service. Alternate service in this case will be by ordinary mail.
Got it.
So when you simply put on there the date and et cetera that you put it in the mail, and that will be your service.
Understood.
All right, so I'm going to have my clerk to email you the motion and affidavit form with the new court date of 12th of June. Then make sure you put that in an envelope. It'd be a good thing if you take a picture of the envelope, address to Mr. Carter, and attach that copy of the envelope with a stamp on it to your proof of service. turn that into the court. That way, when you come next time, the court can issue a bench warrant if he doesn't show.
Got it.
Understand?
Understood.
All right. Wish you well. We'll get this to you. Madam Clerk, you have, when you get the email this back to you.
Yeah.
Okay. All right. So we'll get that email over to you shortly, sir.
Okay. Thank you very much.
Good day to you.
You as well.
Mr. Fortner, are you there? I received the various notations. Are you there, Mr. Fortner?
He's still in Joseph's courtroom over in Third Circuit, if you can pass him for now.
Oh, yeah, I will. I saw notations, so I was responding to that. Thank you. I'll come back to it.
Okay.
All right, this is case number 2416-0951. This is HS Financial Group, LLC versus Sidney Halliburton. The matter is before the court, set on for pretrial date. I also have another scheduled for a hearing on the motion for summary disposition. Your appearance for HS Financial Group.
Good morning, Your Honor. Denise Baker, P53670 for HS Financial Group.
All right, thank you, Ms. Baker, and good morning to you. I'm looking now for Mr. Sidney Halliburton. If you're on the Zoom, say something at this time, Mr. Halliburton. I see. Mr. Halliburton, have you seen him this morning, Madam Counsel? Right, I don't see I don't see where Mr. Halliburton has appeared. Sidney Halliburton. So the court did send a notice on May the 13th indicating that today is the date for hearing the motion for summary disposition. The court also sent a notice regarding this matter being a pretrial date as well. Counsel, any other information you have, any information you have about why Mr. Halliburton is not here? Have you spoken with it? Anything?
No, Your Honor. We also mailed a copy of our motion for summary disposition to the defendant on May 6th at the same address that the court sent the notices to. We have not received a response. No response to the request for admissions, which included a statement that please admit that a principal balance of $8,639.02 remains due and owing. We'd ask that a motion for summary disposition be granted on the merits, not on a default, based on the fact that there is no genuine issue of material fact. This is a default under a retail installment contract. The vehicle was repossessed and sold. This is the deficiency balance that's due. We have attached a copy of the lease contract, the copy of the assignment to plaintiff herein, a copy of the ledger, and a copy of the request for admissions.
All right, I have reviewed the motion for summary disposition in this matter. That sounds in MCR 1.116C, C9 and C10, as well as other provisions. It does not appear that there's a genuine issue of material fact. Moreover, looking at the pleadings as submitted to the court, the defendant has not pled a defense to the claims that have been asserted in this matter. Based upon the pleadings and based upon the fact that there does not appear to be a defense in this matter, the court would grant a motion for summary disposition at this time and will sign an order based upon granting the motion for summary disposition. that will allow for entry of judgment in the amount of $8,891.02. That is inclusive of costs and statutory attorney fee. The court has granted the motion, and the order is entered at this time.
Thank you, Your Honor. And the court does have our judgment we submitted.
Yes, ma'am, it's been signed.
Thank you, Judge.
Thank you.
Have a good day. Have a nice weekend.
The court now calls case number 24-172-658. This is Northwood Radiology Incorporated versus Smart. The matter is before the court, set on for a pretrial conference. Your appearance for Northland, please.
Good morning, Your Honor. Mike Fortner is here on behalf of plaintiff P46541. Good morning to you.
Good morning to you, sir. And let me see if I have a counsel for Smart at this time, please.
Yes, good morning, Your Honor. Kyle Macbeth for Smart.
All right, go ahead with your P number, Mr. McBeth.
72174.
All right, thank you, counsel, and good morning to you, sir. All right, go ahead and update me on this. I think I already issued a scheduling order regarding this matter. So, Mr. Porter, update me on where things are at this time, sir.
I believe things are just really getting started. Am I correct, counsel?
Yeah, you're correct. I think you've got some discovery answers that are due today, and looks to me like maybe your bill has gone up since you filed it, but I guess I defer to you on that.
Well, probably have.
All right, so I do see that I had a discovery cutoff for today's date, but it seems that things are going along reasonably well. So it seems to me maybe it makes sense to leave discovery open and set a final pretrial conference date.
I think that makes sense, Your Honor.
That works for me.
Sounds good. All right, so I will set the matter up for a final pretrial conference, and I'm going to set that up for the 30th of June. Does that give you enough time to kind of close the loop on this, Mr. Porter?
Yes, Your Honor.
June. Mr. Macbeth?
Yes, Your Honor.
So it's being set for a final pretrial conference on the 30th of June. Unfortunately, I won't be here anymore, but somebody will be here, and my notes will tell them where things are.
Well, Your Honor, we don't like you not being there. We like a sure thing. So that's a problem.
Yeah, I understand, but I'm transitioning based upon another appointment from the Supreme Court. So moving forward. So it's been a pleasure. If I don't see you again, Mr. McBeth, it's been a pleasure. Good day to both of you.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah, I've got one more, I believe.
All right, I'm coming to that in just a moment, Mr. Moore.
Okay, Your Honor. Thank you.
All right, this is case number 24-16984. This is DME Dudes LLC versus Smart. The matter is before the court. Set on for a motion hearing. Your appearance for the plaintiff regarding this matter.
Good morning, Your Honor. Joshua Beagle on behalf of the plaintiffs.
Thank you, Mr. McNeil. Your P number, if you will, for the record.
79335.
All right, thank you, sir. Good morning to you. For the this matter,
good morning, Your Honor. Veronica Prang, appearing on behalf of defendant Smart, P number P83356.
all right, thank you, counsel. Good morning to you as well. I do
Morning.
see that there is a motion that looks like it's been pending, but it has the 11th of December. That would be something I would typically rule on. So somebody update me. Tell me what things are.
Yeah, so Your Honor, we filed a motion to dismiss due to plaintiff's failure to timely pay transfer fee. You denied that motion back in, I believe it was February. There was some administrative issues getting the order to you for signature. That was only entered, I think, in March. We filed our motion for reconsideration. There was a pretrial conference scheduled, I think, last month that we appeared for. And at that time, you set the motion for reconsideration for hearing. In the meantime, though, our office also filed a motion to compel the deposition of plaintiff's representative. We filed that a week ago. It's not clear to me, I guess, if that's before you today. We did request that it be set for hearing today as well.
And I don't see where the motion to compel has populated to the file. So I don't have that in front of me.
I think the issue, Your Honor, if you recall, you and I spoke last hearing. There's this case was originally Judge Robinson's, and you stepped in, and it got reassigned to Judge Sabri. I think that motion to compel maybe went to Judge Sabri.
All right, so that's what's going on with this, and so obviously and interestingly, you guys have on this file had to deal with 3 judges: Judge Robinson, Judge Coleman, and Judge Sabri. Well, I'm leaving. Judge Sabri just got appointed to the circuit court, so now you're gonna have a 4th judge, and I can't tell you. I can
Oh my
tell you
gosh.
this. So, I guess I need to. I guess I need to set a date for it to come in front of the judge. That's what the judge is going to handle this in the future. My replacement, at least temporarily, is going to be beginning next week. As tomorrow is my last day. And Judge Spree is due over the circuit court on the 6th of June. That's our start date. So it's definitely going to someone else if we don't know. So I just wanted, I felt it necessary to kind of tell you all this thing because I know it's been a little bit interesting. Unfortunately, you know, you're gonna have a cloud of even more intrigue. So, so I suppose I just set it up in front of the new judge. My notes are a document, but I think it's best that you move forward with the new judge.
Okay. Yeah, I have no objection, Your Honor. I'll leave that to the discretion of the court. I guess the only thing I do want to say is, as far as the motion for reconsideration, because you were the judge that made the determination to deny our original motion to dismiss, I'd request that if Your Honor could consider it before you leave, that would be much appreciated. Just because I would worry that there'd be confusion after you leave regarding a determination on that.
All right, absolutely. And you may proceed on the motion for reconsideration of that. I do in fact have that scheduled.
Yeah, Your Honor. So it is straightforward. I trust you know you well enough at this point, Your Honor, to know that you've read the brief. Just generally, as our brief indicates, MCR 2.223 dismissal under that court rule, there are no savings provision. There is no discretion as to whether or not dismissal is mandatory. The language of the court rule requires dismissal when transfer fee is not timely paid. And I understand Your Honor made a determination at the original hearing that plaintiff substantially complied, but substantial compliance is, again, not a defense to dismissal under the court rule. There is no savings provision. There are no defenses to dismissal under the court rule. It's mandatory. And secondarily, Your Honor, Your Honor indicated at the hearing on the motion as well that even if you did dismiss the case under the court rule, that were plaintiff to make a request to reinstate the case, you would do so. because of the substantial compliance regarding attempt to pay. However, Your Honor, as we indicate in our motion, the purpose of this court rule is to ensure finality. It's to ensure that transfer fees are timely paid, so that defendants aren't wondering the time frame in which they might be sued or need to defend. While there was payment close in time, Your Honor, this court rule is similar to a statute of limitations in that if you miss the deadline, then there's no savings provision. You can't come back and say, even if you file the next day, that you're entitled to, under the No Fault Act as an example, request payment for, days of service for the day that you missed, right? Council was made aware by the 48th District Court of the requirement to pay the date it was due. They did create a letter on the day they received the correspondence, but merely mailed the check instead of taking the check down to the court, ensuring that it was provided timely to the court. This case must be dismissed under the court rule, and reinstatement would undermine the legislative purpose of the court rule to ensure finality of cases under the court rules.
Right. And I understand the argument that you made. And thank you for the reminder with respect to the court's reasoning as it relates to this particular issue. Obviously, the challenge is always to think about the issue of finality, that a sort of something that seems to be a procedural failure, perhaps, would result in could likely result in impact on substantive rights. So that's kind of the quandary that the court has to weigh in considering this. But Mr. Beagle, there's an indication that the court rule perhaps maybe it needs to be amended or something, but the court rule as it stands, it looks like it's pretty restrictive in terms of deadlines for paying fee for the transfer, that we're not, there's an indication that the case should be dismissed. And I don't think that the court rule does not speak to a dismissal of prejudice, but it says dismiss. Go ahead, Mr. Beagle. Let me hear you.
No, I mean, this is a motion for reconsideration. So, I mean, our arguments were made at the last hearing. And I'll point out for the record again, they don't read the entire court rule. They don't read the last sentence. And there's a reason they don't read it. If it was meant for finality, then that sentence wouldn't be there. So I think the legislature is pretty clear that this isn't a finality. And whether council feels there should have been somebody that dropped it off in person or mailed it is irrelevant. It was paid timely. Their interpretation of it is different, obviously, but I'm not going to relitigate the last motion. That's not why we're here today. And I think it was properly decided in every way. Every argument was addressed appropriately.
All right, and Council, when you make reference to they don't read the rest of the court rule, tell me what you're talking about. I know that we went over that before.
We litigated that extensively. It says right at the, I don't have it in front of me again, this the very last sentence, you don't copy and paste it in there. It provides that it should be reinstated or some sort of language regarding that it's not a permanent dismissal. Essentially, it's a timing mechanism. If there's delay, then they don't want it just sitting on a docket waiting for the court to be, to issue scheduling orders, things like that. But in this case, there was it's 3 days. I mean, we're not talking about 4 months and nobody knows what's going on. We mailed it the same day, and the stamping issue or who processes it at 36th District Court is what they're hanging on. So,
Your Honor,
So, yeah, you made the comment.
so the section of the last sentence of the court rule, he's correct. We don't cite to it because it doesn't matter. It's a section of the court rule that states that the case must be stayed pending the payment of the transfer fee. The case doesn't, it just means that aspect of the court rule simply states that nothing can move forward until the transfer fee is paid. It's a directive to the court that's receiving the case that nothing can happen, nothing can be scheduled, etc., until the transfer fee is paid. So that aspect of the court rule has nothing to do and does not affect the mandatory nature of the court rule itself, where it says a case will be dismissed if the transfer fee is not timely paid. Your Honor, this, as it relates to the mailing of the check, it was mailed on the day it was due. And that means that the court could not possibly have received the check timely in order for it to be a timely payment of the fee. So there's no mailbox rule as it relates to this court rule. If, again, you know, we bring up the fact that they could have brought it to the court because I think I indicated at the last hearing, Your Honor, I was a plaintiff's attorney for 2 years. If we had a statute of limitations coming up, they sent me down to the court. They'd send me to 48th. They'd send me all over the place with the complaint and the check and everything else that we needed to make sure we got timely paid. Not to say that we did that all the time, Your Honor, as a plaintiff's attorney, but I will say that, you know, we ensured that, and again, I'll acknowledge too that statute of limitations is different than this court rule. I understand that there's a difference between those two things. But I'm saying the similarity is enough to say that if I had a deadline and I needed a check to be paid and to ensure that my case wasn't dismissed, that I'd run the check down as opposed to stick it in the mail. It wasn't timely paid and could not have been timely paid if it was mailed on the same day it was due.
And if apparently we're just relitigating the motion all over again, but again, to that point, the court didn't process it. So there was nothing to pay.
Nelson, one stop. It is a motion for reconsideration, so it's asking me to think about it again and to look at everything, and that's why I'm allowing and I am. So go ahead, anything you wanted to tell me, sir. Go ahead.
Well, I understand the reconsideration, but it's, I mean, we're not able to file responses. It's generally not set for a hearing, but for the purposes of what she keeps addressing, the court, 36th district didn't have it to process initially. It was delayed. So her argument that we should have just brought down a check, then we're just going to drop off a check and 36th district court has no idea what it's even for. So that's the whole argument. The whole point is of this court rule. If you want intent and all the other stuff, it's so that a case isn't sitting out there for 5 months or 4 months and being scheduled and nobody's paid the fee. Everything in this case happened. We paid the fee. There was already a scheduling order set. There was everything about the transfer was conducted as normal. The only person that has an issue with the transfer and they're trying to claim, well, they didn't cash it in time. And look here, the date of the cashing of this check is different. That's all it is. Nobody delayed in anything. If anything, it takes time to process, but we're not talking about a month even. We're talking about days. It's just a wild argument to sit here and say that somehow they've been prejudiced and that this case has to be dismissed and never re-entered when, number one, there was no delay. Number two, nobody was prejudiced. We're now 6 months after the processing, and the only thing that they're doing is litigating a 3-day-old processing rule. And then three, the entire procedural aspect of it was scheduled by the court. Everything was done. They ignore the last part of that court rule, which is the stay. Nothing can happen until. If the case was supposed to be dismissed and there was finality, then that last sentence is irrelevant. It doesn't matter if they pay the transfer fee. The case has already been dismissed. There's a reason it's in there, and there's a reason they don't cite to it, and there's a reason they take half the court rule. Well, we don't get to do that. We don't get to pick parts of it that we like to fit our argument. There is a reason that sentence exists, and it says there's a stay till it's paid. I can see where there would be discretion if it's 3 months, 2 months, and everybody's wondering what's going on, but there's not. Everything occurred as normal in a normal litigation case.
Thank you, Counsel. You have the last word on this, Madam Counsel.
Yeah, Your Honor, I just want to make clear, we're not arguing about processing. They mailed the check the day the check needed to be received by the court. And we're also not saying they take a check down there without anything else. They can take the order with it. That doesn't matter. They did not make sure the check got to the court in order to be processed. They had notice. They created a letter to this court to send out the check with the information needed. On October 31st, it was due by November 4th. They didn't send it out until November 4th. If they had sent it even 2 days before, the court might have received it. We wouldn't have an issue. It wasn't timely paid. And I'd like to point out to Your Honor, prejudice isn't the standard. It's a mandatory court rule.
I just want to dispel the notion that the defendant motion sounding some nebulous kind of claim for it special. It really is rooted in the court rule that has been referenced here, Rule 2.223 C1, where it says the plaintiff must pay to the receiving court within 28 days of the date of the transfer order the applicable amount of the costs and expenses as ordered by the transferring court or the receiving court will dismiss the action. That's where the motion arises. It rises on a court rule that probably there are some other considerations that should be raised. Certainly, one has to think that what the drafters had in mind was people who are intentionally or negligently delaying the advancement of a case by the failure to pay the fees in a timely fashion. The latter part of that rule says no further proceedings may be had in the action until a payment has been made. None of this evidence where that applies. Is that a saving clause, or does that simply give reflection on that 28-day period where no action can be taken during that period of time? Certainly, if the case is not properly transferred to the court, then no action could have been taken in that case anyway because it's not properly transferred. So the language at the end that no further proceedings may be had in the action until payment has been made, that obviously makes sense, both in terms of when the court has full custodianship over the case, as well as it seems to suggest that the making of payment could have the effect of the reinstatement of the case, although it doesn't say that. That's why some of this is on a bit of some nebulous grounds in terms of how the rule is to be interpreted and how the rule is to be applied. In this case, I cannot find where there is a unreasonable delay in responding to the requirements of the court rule. That the placing of the payment in mail on the date that the payment was due, that there is some argument that the court may not have already received, may not have received the file, so that an earlier payment may not have been a reasonable thing to do. But all that being said and done, this does not represent a situation where it appears that the rule will require essentially a dismissal with prejudice. I don't see that the rule is pointing in that direction. For that reason, I will deny the motion to dismiss the motion for rehearing reconsideration of this matter. The court has reconsidered, and these order previously issued in this matter will remain in place. The motion to dismiss.
Thank you, Your Honor.
I'm going to give you the next action date in this matter, and I'll set it for pre-trial and review. You'll be able to update the judge who will be sitting here regarding this matter. So why don't we put that? July the 1st, 7/1, 25. And I'm going to set that at 9:30 a.m.
You said 9:30, Your Honor?
Yes.
And to be clear, Your Honor, we'd like discovery to remain open. Like I said, we filed a motion to compel the DEP, and we are also, we submitted a stipulated order to compel supplemental responses to discovery, which still hasn't been entered. We submitted that back in March, so we're waiting for some supplemental responses as well.
Right, I will allow discovery to remain open, and my note will say that discovery is to be reviewed on that date. And of course, I'll go ahead and set that motion for hearing on that date as well. It's not in the file at this time.
Your Honor, we can address that if you want, just so that we don't have to come back in the meantime. They have a motion to compel it. We offered up dates for April after their request. They couldn't make it work. And so they sent a stipulated order last night wanting to compel it by the 30th. I'm not going to enter a stipend order for 8 days, but we did, I believe, have a date already scheduled with their office. So it should be proceeding. So that should be an irrelevant motion. And in that token, we'll be filing our motion to compel their adjuster debt, but we'll offer dates and stuff at that time. But I don't think there's a reason to come back for a motion if that's issue's been addressed sufficiently for Veronica.
Your Honor, if I may.
Yes.
That's not a complete picture of what's taking place in this case. We filed a notice for the DEP back in January. We've gone back and forth a number of times for months, Your Honor. He is correct. They offered 2 dates in April. One of the dates they offered was the date and time for the last pretrial conference. They offered 8:30 a.m. On I think it was April 28th, which was again the date and time for the pretrial conference. So we both had a conflict. We couldn't have done that, and they only offered one other date.
I didn't have a conflict.
Sorry, Josh, if you just let me
You're
finish.
speaking for me. I just want to correct it.
Well, I don't want you interrupting anybody, whether they're speaking to you or not. You know how this goes. You get an opportunity.
I apologize, Your Honor.
Thank you, counsel.
I don't want to, get into too much of the nitty gritty, Your Honor. Needless to say, we've gone back and forth a number of times. The last number of instances, we haven't received responses. He is also correct. We filed a new notice of deposition. We arbitrarily noticed it. I'll admit that as well. For May 30th, we filed our motion to compel. In the meantime, we didn't hear from them until this past Monday when they asked us to confirm it. We are indicated last night, I spoke to counsel, I said that we were going to move forward with our motion solely because of the difficulty we've had in ensuring this deposition moves forward. So, I understand the motion's not before you, Your Honor. I know we're talking about it now. We wanted an order just to ensure that this deposition moves forward as scheduled, again, solely because we've had difficulty in getting it on the books and getting it done.
All right, so let me say this, and then I'll come to you, Mr. Beagle. It looks like there may be some effort to try to work on that. I'm simply going to put that motion over to 7-1. If you get everything worked out and you don't need it, then you won't argue that. But my notes is going to say that motion is pending. And if Mr. Beagle has a motion that he wants to file addressing discovery 2, just set it for hearing on that date. You file it, notice it, that's the date of hearing. And those issues will come.
I was just going to bring that up. I was just going to bring that up. I mean, if that's a response to it, then I want the motion to go forward. So we can leave that on the docket, address it then.
If in the interim, I mean, between now and then, it's about setting dates. If you get stuff worked out, then you don't have to address it on the 1st of July. Not to that date open, right? All right, I'll see you. Wish you all well.
You too, Your Honor.
Well, Your Honor, I think I heard you say that you got appointed to the Supreme Court.
No. The Supreme Court, I'm appointed to as regional administrator for Region 1, managing state courts in all of the courts in Wayne County.
Congratulations.
Well suited for it, Your Honor. Thank you.
Thank you.
Thank you so much, Your Honor, and good luck.
Thank you. All right, Mr. Fortner, I hope you're still there. I thought that that case was your case, but this is case number 4170445. This is Roger Chiropractic versus State Farm Mutual Automobile Insurance Company. Your appearance, plaintiff.
Your Honor, Mike Portman is here on behalf of plaintiff P46541.
Thank you, counsel. Your appearance for State Farm.
Good morning, Your Honor. Genevieve Lee, P84337 on behalf of State Farm.
All right, thank you, Ms. Lee, and good morning to you. So tell me you guys got this all settled while I hit you with waiting. Update me.
Yes, Your Honor. So we still have an offer of judgment pending, and opposing counsel still has the opportunity until Monday to either accept or reject that offer of judgment. In honesty, I don't know what's outstanding. To my understanding, most, if not all of this bill is paid. And so we're hoping the offer of judgment resolves it. If not, we can proceed with the final pretrial and discovery open so we can better obtain plaintiff's bill and understanding of what's left, if anything. But I'm good with an adjournment with discovery open if necessary.
Hey, Genevieve, will you email me that offer of judgment again? And I'll get you the current bill and we'll see if we can get it wrapped up today or tomorrow.
Okay, very good.
All right, very well. So I'm just going to set it out a few weeks, and if you all get it all wrapped up, you just send some paperwork, and all should. So I'm looking now to the 12th of June. So 6/12/25, and I'm setting it for review on that date. And again, if you've got it all worked out, and you submit the paperwork and everything. All the best. Thank you for your patience.
Your Honor, may
Thank
I
you very
ask,
much, Honor.
that was June 12th at what time?
9:30.
Okay, and is that a regular pretrial or a final pretrial?
That's it. I sent it as a review, because there's going to be a new judge here, so I want you to, be able to tell them what you need. So I'm just sending it for review. If you need to.
Understood. Okay, so parties are to appear then. Thank you.
And all the best.
Thank you, Honor.
Thank you. All right, this is case number 24175722. This is American Express National Bank versus Stephen Property Management LLC, also known as Stephen Hepburn. For the court, set on for looks like I have it set for a status conference, but in the interim, a motion to dismiss this matter and file as well. Right, your appearance for American Express.
Yes, good morning, Your Honor. John Whitty, P66880.
All right, thank you, Mr. Whitty, and good morning to you, sir. I'm looking now for Mr. Hepburn, Stephen Hepburn.
Here, Your Honor.
All right, thank you, Mr. Hepburn, and good morning to you, sir. All right, so I do see that there is a defendant's motion to dismiss this matter in lieu of any answer to the complaint. Counsel, you received that document, did you?
Yeah, we did, Your Honor, and we did file a response to that. We've also spoken today prior to appearing. We're discussing resolution. I'm going to send him a couple proposals in writing that he can review. So we talked about one of two things, Your Honor, either adjourning this out or doing a scheduling order with dates to adjourn it out. And I'm not sure how Mr. Hepburn wants to handle his motion. I'll leave that up to him then.
All right, so if you're talking about it, it does make sense to extend it out just a little bit to give you opportunity to see if that's going to happen.
And he's also having some eye surgery. So if we do adjourn it, Your Honor, and it sounds like it probably would be anyhow, we were looking for like a 45-day, 60-day adjournment, just so he's.
All right, Mr. Hepburn, anything, sir?
Say that. Repeat that.
Now, based on this discussion, anything you wanted to say, sir?
No, because I think we can iron it out outside of court, and hopefully we can get this thing dismissed and not just pay him, what we agreed to. And I just need my eyes fixed so I can read his proposal.
Sounds good. I hear you. That's those of us that wear glasses and all kinds of stuff, we understand. We think better when we can see. The food tastes better when we can see everything. All right, so what I'm going to do is I'm going to set another date for the parties to return and to keep working on a possible resolution. So that date's going to be 14th of July, 7/14, 7/14/25. Get it worked out sooner than that. then you can send in paperwork, that'll move it off the calendar. If not, then you'll be here on the 14th of July at 9:30.
Okay,
Sounds
I'm
good, Your
sure
Honor.
we can come to terms.
All right, good day to both of you. You'll get a notice in the mail as well.
All
Thanks,
right,
sir.
thank
Good luck.
All right, this is case number 24241394. This is Kenneth J. Bunch versus James Sims. The matter is before the court, sent on for a trial on today's date. Please step forward to the podium area. Mr. Bunch should be on this side, Mr. Sims on this side. All right, and your name for the record, sir?
L. Bunch.
All right, thank you, Mr. Bunch. And you brought this action. I noted that the action was initially brought in the small claims division of this court and was ultimately transferred to the general civil division. Is that correct, sir?
That's correct, Your Honor.
And your name for the record, sir?
James Michael Sims.
All right, thank you, Mr. Sims. And you responded to this matter and you're ready for the hearing in regard to this matter today. Is that correct, sir?
That is correct, Your Honor.
All right, very well. So, gentlemen, I want both of you to raise your right hand and sworn at this time. You do solemnly swear or affirm that the testimony you're about to give in the matter before the court will be the truth and nothing but the truth, so help you God.
I do, sir.
I do. All right, very well. Sir, you may be seated. Mr. Bunch, you get to go first because you have what's called the burden of proof. You have to prove by the preponderance of the evidence that proposition that you bring before the court is supported by facts and law, and after you presented your matter before the court, then Mr. Sims will get the opportunity to present his defense in this matter, and I will weigh his testimony, your testimony, and any admissible evidence in this matter, and ultimately we'll make a decision and determination as to the outcome of this case. So, sir, the case typically begins with an opening statement. The opening statement is not evidence. It's just a brief summation of what you believe you will be able to prove in this case. You have the right to make an opening statement. You can weigh the opening statement. So I'm going to go right into presenting my evidence, or you can make an opening statement. What do you prefer to do, sir?
I'll make a brief opening statement, Your Honor.
You may proceed with your opening statement.
Your Honor, in my opinion, this case is very simple. I gave Mr. Sims my truck on August 9th of last year with the understanding that he would repair the issue at hand. Since that time, I gave him the additional parts. He told me that he needed to repair it, and I gave him all of those parts as of September 23rd. At that time, he assured me that it would take him perhaps 1 day to finish my truck. Well, I'll show in this case that after that date, I contacted him on numerous occasions, and since that time, Mr. Sims has given me excuse after excuse after excuse as to why he cannot give me my truck. It's as simple as that.
All right, thank you very much, sir. Now, sir, you have the right to make an opening statement at this point. You can wait until it's time you present your case. Would you like to make your opening statement now? Or do you wish to?
Yes, sir, I can make it. Once again, good morning, Your Honor. My name is James Sims, and I am a owner of SMS International, LLC. Mr. Bunch left his vehicle with me for a personal, what do you call it, storage while he went out of town and out of country. And he said, in the meantime, you can look over my truck and see why I have a check engine light and what's going on with it. That was in a personal location, not in a business location. I told him, yeah, so doing a favor for a friend of the family, no labor, no charge. This is what I found. This is your problems. This is your fault. I can repair one item if you can send me the money for your parts. And I would not charge you for any labor. That was agreed. And he agreed to no labor. I completely did the job, and then I found more problems. He chose to buy his own parts. He chose to locate his own parts while he was on vacation and he came back. That truck sat with me for 1 month. And from that time, that he never paid any labor, never paid any storage.
You know that you're not doing proofs right now. You just give us some.
Okay, the proof is that he left it with me under the condition of me watching over his truck while he was out of state, out of town. I was not obligated to fix his truck, just give him a diagnostics. So he never picked the truck up and
You don't get into those kind of things.
okay, no, it was just that the one of the meetings.
At some point, you're gonna testify, right?
Yes.
This is an opening statement. It's not testimony.
Okay.
Right? So your summation to me sounds like the vehicle was left with you. It wasn't a business transaction, and he left the vehicle, and you're not responsible. That's what you're saying.
Yes.
You may be seated, sir. All right. You may proceed now with your proofs in this matter, Mr.
Your Honor, I submitted documents to the court showing pages 1 through, well, 1 just showed you a copy of my vehicle, 2 showed you invoices from SMS, which is Mr. Sims' company, in which I paid him for his services for repairing my truck. Your Honor, the truth is, the engine light that have been coming on my truck have been coming on for approximately 2 months. At one point, Mr. Sims asked me to just put some fuel injection cleaner in there, and perhaps that would do it because that was, he thought it was such building up in the fuel line. So I tried that. It seemed to work for a brief period of time, but it did not fix the problem. So what I told Mr. Sims in terms of the 2-week period is this. I was getting ready to go to a convention in Connecticut on August the 9th, I believe, or the 10th, that Saturday. I told Mr. Sims that here, take the vehicle. I'm gonna go to a convention. When I come back from the convention, I'm going on a cruise. I'm taking my brother on a cruise. He's never been on. So I will be gone for 2 weeks. So now take your time. Because again, he's been managing my truck since I purchased it. He's been my mechanic, and I appreciate that. That's what he's been doing. Now, when I left him the vehicle, I say, what will this cost? Now, mind you, he hadn't done any diagnostics or anything at that point. He said, what would it cost? I left it with him on that Friday. and I sent him $2,563. So this was no favor. This is what he told me he believed it would cost. $2,563. I gave him $2,563. He never gave me a receipt for those dollars. He never showed me what parts he purchased for those dollars. He never showed me anything. Now, the last. Sure. Okay. I did a wire transfer. I showed there's a copy of my bank statement there on page 6. It's underlined where it shows that I wire transferred to SMS 2560. Okay. On the next to the last day of the cruise, Your Honor, I called Mr. Sims from the ship. At that time, he told me he needed an additional $7,500 because the turbo, which he contends was one of the problems, as well as the exhaust manifold. He said the turbo alone cost $6,900, and so therefore he needed $7,500 additional. I told him, just hold up, let me get back to the city, and we will go over it, and I'll see how I wish. When we got back to the city, Your Honor, I think it was August the 27th. I do have my call logs there that identify the exact date. Call log, I met with Mr. Sims. He gave us, my brother and I, he gave us an estimate of parts, what these parts cost. Now that's page 9. This is the estimate that he gave us. You will see that if you add all of that up, the turbo does not come to $6,900. The entire bill does not come to $7,500 because Mr. Sims told us that he already put the actuator on it. So his estimate did not correlate with his statement to it. So I say, well, look, I'll just find my own parts because that's what really I've been doing all along. Mr. Sims put a bumper on my truck. I found the bumper, I put it on. Mr. Sims put another air brake system on my truck when it went out. He ordered it, I purchased it. So our relationship has always been, I purchased my parts. But this did not, so I said, well, I'll get my own. And I'll find the parts myself. And so I set out to do that. But prior to my finding the parts, feeling like I did not trust Mr. Sims at this point because that $7,500, I thought that was kind of the floor. I called him up and said, look, I'll fix my own truck. I said, I'll get somebody else. Just give me my truck back. He told me he didn't want to do that. That was on September the 4th. He told me he didn't want to do that because he felt like I would accuse him if something went wrong. I would accuse him of it. So he wouldn't give me my truck at that time. So I found all the parts on September 23rd. I gave him all of the parts, and you'll see an invoice there from Tri-County International, where on September 23rd, that's page 16, where I gave him the parts that he needed, as well as page 15. I gave him the parts that he needed, and he told me it would take him 1 day to repair the vehicle. Now, after that date, and I gave you a copy of my call log, you'll see all the phone calls that went back and forth between Mr. Sims and I. It was, all those phone calls was about, when will I get my vehicle? When will I get my vehicle? And every time I talked to Mr. Sims, it was one excuse after another. One excuse after another. In fact, he told me that his first excuse was that the screws to the turbo were too long and they were hitting up against the manifold. I don't know anything about that, so my thing is fix it and get me my truck. Now, he sent me a text, and I think that's the last page. After I sued him, Your Honor, on October 30th. In December, he sent me a text because I don't think he had seen the suit documents yet. He sent me a text on December 12th, telling me that your truck was done, as completed 10/30/24. No calls or answers for you, no later. Because he told me in that August 27th meeting that I wouldn't have to pay him any additional labor. Just keep in mind, he had $2,500 from me. And he also asked me for an additional $425 on October 3rd. Asked me for an additional, and I sent him that. And I gave you a copy of my statement where I wire transferred those documents to him. So now on December on.
I heard you go over the I believe it's $2,500.
2563, yeah.
Yeah, 63. You said you sent some additional money?
Yes, $425.
The testimony was a request for an additional $7,500. And you did not pay that. Right?
No, I did not.
There was some other money you paid. Tell me about that.
That's the 425. He said he needed some additional supplies or something to finish up the job on October 3rd. I transferred him $425 more. So, Mr. Sims and I talked on numerous occasions. I'm wondering when I'm gonna get my truck, and every time it's one excuse after the other. I met with Mr. Sims. When I gave him the turbo comes with a cord where you have to send the cord back in order to retrieve your money. I met with Mr. Sims on November the 7th to collect that cord. I think it was the 8th, November the 8th, to get that cord back. At that time, Mr. Sims told me that he had put everything back on the truck and everything was working fine. However, it had an engine cooling leak. And that's when I found out that Mr. Sims had basically put his business down and had gone back to work for someone else. He told me this. But my truck did not have an engine cooling leak when I gave it to him. It never had an engine. And he knew that. So he told me that perhaps he would have to take it to the new shop that he worked at in order to fix that. Now, this was November the 8th on a Friday morning. So that was the next excuse that he gave. Your Honor, as late as February the 7th of this year, Mr. Sims and I had a long conversation for over an hour. And he agreed that he would give me my truck that next Saturday morning. I didn't hear from him, so I also gave you a copy of my call log. I called him up that Saturday about 3:30, saying, what is the status of the truck? That's what I called him up to ask. Well, what's going on? You say you're gonna give it to me on Saturday morning. Well, a little over an hour later, he called me back. And he said, the batteries have been sitting for over 3 months and therefore I can't get started. Your Honor, Mr. Sims is a mechanic that goes out on the highway and repair trucks. He's one of those mechanics who can go out on the highway and repair trucks. For him to tell me he can't get my truck started because the battery is dead, I thought, really? So, Your Honor, again, I've been trying to get that's all I want. There was no, I have never asked. Mr. Sims stand before you and talk about a personal relationship. No, I made it very clear to Mr. Sims, because when he talked about personal relationship, that was between him and my nephew, because my nephew is the one who referred me to Mr. Sims. See, he and my nephew discussed going into business together, and he told me all about this. I let him know then, I have nothing to do with that. I want nothing to do with that. My relationship with you is one thing and one thing only. When I need my vehicle repaired, you repair it and I pay you. It's as simple as that. You repair it and I pay you. That's why when he said that it cost $2,563, I didn't even question. I sent him the money. When he said that he needed additional $425, I sent him the money. You'll see on all these invoices, the first two or three pages. When he sent me an invoice, I pay him. I have never asked Mr. Sims not one time to do anything for me for free and to do me any favor. Not one time. Our relationship has been strictly business, and that's it. You repair my vehicle and I pay you. That's it. In fact, there are a couple of times I've had to insist on him giving me an invoice. Because I don't want, you know, if you'll notice on my receipts, on my bank statements there I sent you, it says JK&K Light Trucking LLC. I run my company as a corporation, not as an individual. I run it as a corporation. Therefore, it's my intent to keep all of my receipts. I don't mind paying the double tax because I have to control my income. So I want all of my receipts. I have never asked them to do anything for me for free. You pay me, you keep doing the job, and I pay. It's as simple as that. And all of my documents will show.
All right, let me ask you, sir.
Sure.
So you have not had the control or use of your vehicle since August of 2024.
I have not.
Do you know what the condition of your vehicle is at this time?
I don't know. I do not, Your Honor. I have not seen. I went by Mr. Sam's shop. I've taken a picture some months ago. It was just still sitting there. I went by here recently, about 2 weeks ago. My vehicle is no longer there. I actually filed a police report, Your Honor, to try to get access to my vehicle. They told me that really I'd have to come through you. But they told me when I do get access to it, to call them so that they could be on site when I get in.
To best of your knowledge, sir, what is the reasonable value of your vehicle?
Oh, I paid $35,000.
You paid that.
I paid that in August of 2023.
You don't know what the value of that vehicle would be at this time?
No, I would have to get it.
So you filed your action for $7,000. Tell me about that. Tell me.
Well, at that time, Your Honor, it was October the 30th. The latest documents I sent you, well, no, actually, I brought some of my bank statements here for the record.
No, just attend yourself to my question.
Okay.
You filed a lawsuit. You say that you were claiming damages of $7,000. Tell me about the $7,000. Why do you believe that you are entitled to $7,000? And if there's something different, tell me about that.
Okay, Your Honor, I basically haul for Amazon. I deliver parcel pallets to the postal service for Amazon. And on average, I make about $300 to $400 per day. And I was losing that much money each day that Mr. Sims held my vehicle. Secondly, I have fixed costs approximately $900 monthly because the insurance that we have to pay for the commercial vehicle, my insurance is $666 a month, plus $90 for my electronic log that I have to maintain for DOT money. So those are direct fixed costs that are incurred every month.
You continue to maintain insurance.
Yes, I did, because I was thinking I was gonna get my vehicle at any time. I had no idea why he called. I didn't want to cancel my insurance in case I got it. When you renew, you got to put up double payment. In fact, I just talked to him. Okay. No, Your Honor, other than I'm just need money.
All right, thank you very much, Mr. Bunch. You may be seated at this time. Sir, come to the podium, Mr. Sims. And I know that you have some testimony that you'd like to offer in this matter. Hey, let me start out by asking you a couple of questions. Is it true that the vehicle was submitted to you sometime in August of 2024?
Yes, sir, that is correct.
Is it also true that you have not returned the vehicle to Mr. Bunch since that time?
No, that is not correct.
You gave him the vehicle back?
No, I opened the gate and I believe one of our meetings, it was March the 3rd, we had a Zoom call and you asked, could Mr. Bunch retrieve his vehicle? And I said, yes, sir, that is correct. Yes, Your Honor. The gate was open. He had plenty of time. The text messages, come pick up your vehicle or I'm gonna have to put it in storage. Your vehicle is here. It's on Troy Road, Wyoming, 8900. My fence line is breached. I gave them plenty of opportunity. And like we told you, we talked on the phone, come get your vehicle. And he was like, well, I'm not coming to get my vehicle. It's because I'm gonna sue you for $300 and something a day for being out of service. The tags is incorrect and they expired. He cannot drive the vehicle, so he would have to hire a tow company. Is because he cannot drive that vehicle on city or any roads because that commercial experience insurance is expired on the tax. But yes, he has 100% full rights to come and grab his vehicle. His vehicle was never in a contract. There's no mechanic cleaning.
Let me stop you for a moment. You did in fact receive the vehicle from him. And you're telling me now that, that in March you told me to come and get the vehicle.
That is, no, well, I told him in October, he can come and pick the vehicle up. But I was in your courtroom in Zoom and you asked the question and I told him, yes, his vehicle is always available to pick up. His vehicle was done October the 30th, Your Honor. His vehicle has been ready and rocking and rolling.
Go ahead, tell me what else you want to tell me.
So I have the some of my messages from us, and it was pretty much stating that he is always welcome to come and get his vehicle. Now, with Mr. Bunch, like he said, it was a family affair. In the past, the receipts that he gave you was before when it was business. Then me and his nephew and his great nephew was working out business plans. So Mr. Bunch is the elder, the uncle, but he's always been a good guy. He fishes, he goes down. We talk about a lot. I told him I would watch your vehicle while you go out of town. He went to Connecticut for 1 week. And then he said, after that, I'm getting on a cruise ship and I'm going to the Caribbean. Can you watch my truck? Let me know what's going on with my truck. I got a check engine light that has not been corrected. Can you just take a look at it? So we started off with the actuator. We bought the actuator for $2,500. The actuator was installed. Truck was sitting there. If I need anything from Mr. Bunch at that time, Your Honor, I can call Mr. Bunch. Hey, I need $300. Hey, Mr. Bunch, I need a couple of bucks. And so that next one, he sent $400 and something. Mr. Bunch, I'm having a problem with my yard, my personal yard, not this business yard, personal yard. And I think I'm going to give you 50. He sent me mine. We helped each other out. And I said, I won't charge you for any labor. The labor on these parts and everything, that the work that was done was probably about $3,000 worth of work. I didn't charge him because he's a good guy. He's always taking care of me. I've been to his household. I've been to his brother's household. I've been to the yard where he used to store his truck at. It was never nothing business. It was always just, hey, look here, you rub my back, I rub your back. And then I found out from the old location from SMS is that he was suing me. And so the old landlord said, Mr. Sims, you got a package here and someone, sent a certified package. Do you want me to sign for it? I was like, please. I get over there, open it up. I find out he's suing me. 2-3 days ago, before that, he talked to me with no problem. So he had enough time to sign this, send this out, but he never said, hey, look here, I'm suing you. So the day that I found out about it, I said, hey, what is this? And why is you sending this to the company? You didn't take your vehicle to the company. You brought your vehicle to me personally. And so he tried to start with SMS. And that's not true. And so he bought all of his parts. I did his labor for free. I watched over his vehicle while he was out of state and out of country. And then he said, oh, well, I'm going to sue you for every day that I'm losing work. I want my money in. I want this. I talked to his own family, his blood family. They told me do not trust my uncle. My uncle likes to
Let me
shoot.
stop you for a moment. I can't take into consideration what somebody else may have told you.
Yes.
That's like hearsay. So go ahead and tell me about it.
Okay, so then I said, hey, Mr. Bunch, your vehicle is done. You can come pick your vehicle up. This is October. Nope. I didn't already put the paperwork in. I'm suing. And I'm like, this is not cool. This is not cool at all. This is not how we do business. He was like, Jay, I could have took this to the streets, but I don't want to take it to the streets. I won't do that with you. He was like, so I'm taking it to court. Okay, fine. I left that alone. Okay. But dude, I never charged you any labor. I never charged you any storage. You left your vehicle here. My gate is open. Other trucks that's parked there come in and out. You can always come and get your vehicle. You can always tow your vehicle. Just give me heads up and say, hey, look, I'm towing my vehicle out so I don't make a police report saying someone stole your vehicle. So you put me in a bad situation to where, okay, now I gotta go park this truck that has a new turbo, new manifold, new EGR, everything that's put back into it. I have to go park it as storage on Wyoming, right before Warren Avenue in Dearborn. It's because it's not safe to just sit there. This truck runs. I got, equipment that's trailers and stuff that don't run, that's sitting there. But I gave him every opportunity to come and get his vehicle. And then when we was in court on Zoom, you asked that question, and I specifically said, yes, Your Honor, he can come get his vehicle at any time. He chooses not to come and get his vehicle. As of today, he still have not came and got his vehicle, and the gate is open.
Where is the vehicle at this time?
8900 Joy Road, Detroit, Michigan, 48204. 1131.
All right, anything else you wish to tell me, sir?
Not at this time, Your Honor. But
let me ask you this one. How long have you been in the business of repairing vehicles of this nature, trucks?
after I graduated from, after I left from University of Detroit Mercy, I went to United States Army. That was in 1997. I have.
You've been doing this work since 97?
Yes, sir.
All right. The place where the vehicle was dropped off, when you first brought the vehicle to you, is getting ready to go on a trip. Where do you think it is?
8900 Joy Road. And everything was sent to a whole new address. I had no, he knew he'd never been to that other address. So the same place he dropped it off, is the same place he could pick it up. I did not pick it up. I didn't tow it in. He drove it in.
All right. And was there ever a contractual document issued between the two of you when the vehicle was dropped off?
No, sir.
At any time that the two of you entered into any written type of contractual agreement?
No, sir.
You did receive some money for the repair of the vehicle when he left to go on his cruise or convention, correct?
That is correct.
$600 or so, correct?
That is correct.
You received an additional $400+ subsequent to that time regarding some parts or something, correct?
That is correct.
Any other money that you received?
No, sir. No, Your Honor. And can I?
Any other money that you billed?
No, Your Honor.
You did bill for $7,000 for an overhaul, but that was never paid and you never entered into that agreement, correct?
That's negative. There was not an overhaul.
Or whatever it was, there was an amount of money that you said that you needed. Is that correct?
Yes, that was not billed. That was not an invoice. That was a quote. And that quote, Your Honor, was for him to know exactly what the cost would be up under SMS International to repair his vehicle. And he denied that. And so he said, I will buy my own parts.
Got it. What was that amount that you were requesting at that time?
Give me 1 second, Your Honor. That amount was $7,340.83, and that was for all of the parts to redo his exhaust system, and it was an estimate, and the copy and everything states estimate.
All right, and that was never paid, correct?
That was never paid.
Anything else you want to say?
No, Your Honor.
Are you ready to see it? Mr. Bunch, just come to the podium for just a moment, sir.
Yeah.
So what has hindered you from simply going there or having someone to pick your vehicle?
Your Honor, when I hear Mr. Sims state that, I have a picture right here. My vehicle is behind a locked fence with a chain on it. And I shared that with the police department when I went to see them. And this chain has always, every time I've gone by there, this chain has always been there. Mr. Sims will have to schedule a time for me to come and pick up my vehicle. When he told you during that Zoom meeting that he can come pick up his vehicle anytime, well, you can make that statement, but when you have a chain on the fence, you have to let me know when I can come pick up the vehicle. And since then, I have talked to him on a couple of occasions every time. Again, I talked to him just a couple of weeks ago, and he said the battery wouldn't start. That's why I couldn't come pick it up. I mean, Your Honor, this vehicle has been behind this fence, and now he said that the vehicle is still there. This picture shows that it's missing. This vehicle shows that it's gone. This is his shop, 8900 Joy Road. This picture shows that it's gone. Now, I do have pictures where I went by there earlier, a few months ago, and it was sitting there, but it showed the same chain up lock fence, maintaining my vehicle. Mr. Sims has never given me access to my vehicle. Now, he stood there and he told you that he had text where he said, come and pick up my vehicle. Your Honor, I challenge him to show you one of those texts.
Did you ever receive a text?
No, I'm sorry.
Did you ever receive a text that told you to come and pick up the vehicle?
No, I received it.
You indicated to me earlier that there was a scheduled Saturday that the vehicle was to be picked up.
Yes.
Right. What month was that in?
That was in February.
And when you went there on February or when that time approached, you were not able to access it.
I didn't go. What I did was he said Saturday morning. So I waited on Saturday morning for him to give me a call. I didn't hear from him. So I called him on Saturday afternoon, said, what is the status of the vehicle? What's going on? I showed you my call log, you have it. And he called me back approximately an hour later and said, the vehicle won't start because the battery's been taken out for over 3 months and I can't get it started. Your Honor, the only text Mr. Sims has ever sent me, you have is page 26 of the documents I sent you, where he stated, your truck was done for ash completed, I'm quoting exactly, 10/30/24, no calls or answers for you, no later. Now, I responded back, not sure what this means. Perhaps you should clarify. Because again, when he put that October 30th date, I knew I met with him on November the 7th. I met with him. That's when he told me that the vehicle had engine cooling leaks. So that was after October the 30th. So that's why I didn't know this October 30th date. He told me in November that he had to take the vehicle to his other shop to fix the engine cooling leak. So that's not accurate. For him to say that I've had access, that is not true. And now he said he has texts to show that he texted me. I challenge him to show you one of them.
All right, thank you, sir. Thank you, Mr. You have printouts when you.
I do not have a printout, but I can show you the text. It's pretty much the same one you have. A lot of the times when I text, excuse me, I'm sorry. A lot of the times that I text, he calls me back. So it becomes a verbal. It does not become a text anymore. Now, with that being said, and what he was saying, is that yes, I told him, hey, look here, you have a coolant leak. That's outside of my nature on that problem, but I can fix it for you. And he was like, oh, then what fix it? I live 8579 Kentucky, 48204-1131. I'm literally 6 houses away from the yard. My wife works at home for a major health insurance company. She's at home every day. Keys, 2 vehicles in the yard. He does not call and say, I'm coming to pick up my vehicle. I'm not going to call him this because I still have to go to work. But he has not called. Your question is, do I have a text? Yes, I do have a text, and he will answer the text as verbal and will call me and say, hey, look here, where are we at, Jay? What's going on? Hey, look here, we got a little coolant leak. Want me to fix it? No, man, I want my truck. All right, come and get it. So then he comes up there. The truck has been sitting for 3-4 months in the wintertime. We talk about diesel, you know, big box trucks, 26 footers. It takes 3 batteries. It has corrosion on it. I'm not here to fix corrosion or doing electrical. So when it hit the ignition, click, 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 click. It was, I come back, I come and get it later then. Can you get the battery started? I can put it on the battery charger. But remember, I'm not charging you for labor. I'm not doing anything. So when I get to it, when I get home back to the city, I will put it up on the charger. You're right. I forgot that night. I come home. It was getting dark at like 4:30, 5 o'clock. I come home, I go back. I don't have no lights in the yard. So then, hey, the gate is open. Now there's other 2 trucks that he probably sent you a picture that parks in their yard. So in the morning, they unlock the gate. They pull off. They go hit the road. They go down to the container yard. They come back. The gate is open. You have your keys. I don't have your keys. You took your keys with you. I told you I have a master's set as a diesel technician, but you have your own keys. You can come take your truck anytime. Your truck was starting and running. He never came and got them. He wanted to continue to pursue on as of today, May the 22nd. He still have not. He told you he went by and took pictures and looked and this, that, and the other. Hey, then what's wrong with, hey, Mr. Sims, can you please come and unlock this gate so I can get my truck out?
Is this truck on private property, sir?
Yes, sir.
All right, at this point, the parties do have the right to make a brief closing statement, summation. If you want to summarize, plaintiff gets to go for first independent and then the last words. You get to go first. Just a summation.
In summary, Your Honor, I'm disappointed in this, what I'm hearing today. All I've tried to do since Mr. Simmons but at my son is get my view. That's all I've tried to do. And if Mr. Sims at any time ever indicated to me that my vehicle was available for me to pick up, please show up here at this date, at this time, you can have your vehicle. I would have been there on that date at that time. Your Honor, I am a retired postal district manager. I do not play games when it comes to my business. This is a business that I use to assist in paying my children's college tuition. That's all I need. I deal with, in my professional career, Your Honor, I dealt with postal inspection. My job called for me to interact with postal inspector as well as the postal OIG. I do not, this is not a hustle for me. That's why I put it in a form of an LLC to do business. And for Mr. Sims to stand here before you and tell you all kinds of stuff like, Mr. Sims has no clue where I live. For him to say he's been to my house, he cut my grass or anything like that, Mr. Sims has no clue where I live. None. He knows where my brother lives. And he's been there one time. Mr. Sims had no idea where I live. Now the address on all of these documents is Grosse Point Farm, 18600 Mac Avenue, which is the post office. Sims has no idea where I live. So for him to stand before you and give you this story, like we were great friends and all of that, I made it very clear, Mr. Sims, my nephew warned me about this thing.
I want to hear what your nephew has.
I understand, but my point is that, no, I made, the premise of that is, I made it clear to Mr. Sims. All that he was dealing with him, I wanted no part of that. You fix my truck and I pay you. It's as simple as that. You fix my truck and I pay you. And that's what has happened. And since that time, since September, after I gave him all those products, all I have gotten is excuse why I cannot pick up my vehicle month after month after month. I showed you my call log. We show you all the calls that I've made. You will see that every time we interacted, I initiated the call. Mr. Sims would call me back sometime. But now you say he has text message, I challenge him. He doesn't have any text message. He told me ever to pick up my vehicle and made it accessible to him.
Right, thank you. You get to summarize briefly, sir, and then Mr. Bunch gets the last word.
Your Honor, actually, to start off with, the last business dealing that I did with Mr. Bunch, which was JK and K Light Trucking, was actually July 26, 2024, fully paid, $250. And I believe the original deal was like $400 and some dollars. All worked out again. To me, he was a great man. He's still a good man. I think that we have more of a personal, a business / personal confliction right now. But however, as a good man that he is, retiring, he's been awesome. He really has. He taught, but sometimes with older people, they don't want to pay full price. If he had the money, he had everything, he would have took it to the dealership. He bought it for $30-something thousand, had a warranty. 2 or 3 of the jobs, that was just the last one I told you about in July. 2 or 3 of the jobs, he has a warranty on. Hey, Mr. Sims, can SMS do a warranty job for you? I want all of this done because they're paying for it. I don't want to engage into fraud. But however, does it need to be done? Can it be done? With the root cause overall? Yeah. I wrote everything out for him to charge his insurance or warranty company back for him to get paid. I did a lot for him. He took care of me in the past. I felt it was my honor to be able to give him something back. It's because he did make sure when I was down and it was business, that he paid me good money because he was getting back from the warranty. So now how this led off to a personal issue is that he was going out of town. I believe that he just wanted the vehicle to be stored up underneath someone can watch it. Now, Your Honor, I did not lie to you, or if I did, I misspoke. I've never been to his house. I've been to his brother's house. I never cut no grass for him. I'm not into grass cutting. Matter of fact, I got my own landscape. But however, he needed a favor. And he was a good man. And so I'm like, okay, fine. Can you look over my vehicle? Yeah. So as you can see from some of the evidence that he gave you, or discovery that he gave you, is I gave him estimates. I never charged him. And the text I was telling you about, I told him that his vehicle has been done since October the 30th. And your vehicle was ready to be picked up at any given time. He does not call me, it's because he's busy doing his thing too. And so he doesn't call me. Well, I still have to work, Your Honor. And so I go to work every day, 7 days a week. I go out to Romulus. And I have my own service truck. I have my own semi truck. I have my own vehicles. I don't need them. I have a wife that's at home. I have two drivers that have keys to the gate that he can open up at any given time and go out. Was his truck moved from one position to another to protect it? Yes. Just because I am in Joy Road in Wyoming area. They did breach my gate. So I did move it out of the line of fire. However, Your Honor, my conclusion to this was I think this got a little bit messy. It was bad communication. And he went after SMS in the beginning and he sent it to Schaefer Road, Schaefer Highway. I was not aware of it. He did not tell me about it. And I did not hold anything against him. No, I mean, I could have did a countersuit months ago. I didn't do any storage. I didn't do any labor. I didn't do any additional nuts and bolts and parts. Only what he needed to get that truck up and running. It's because he said that, hey, I have the engine light on, and sometimes he'll be coming down the highway and it'll boggle down to 40 miles an hour. It took me a minute. I bought the part to SMS International for the actuator. It turned out to be more. But however, I did everything I could for Mr. Bunch. And for Mr. Bunch, he had the opportunity, but I believe that he was looking to offset his expenses and his insurance. And you asked a direct question. If we was to go any further, I would like to see proof. It's because I have the truck in my possession, in my yard, does not have legal paperwork, does not have legal tags on it. And if you go back on that and you look at what he stated, he said, yeah, it's completely insured. You can't do no fault or no partial insurance on a commercial truck. And then if you're gonna sue me for $300 a day, show me your contract. I mean, I'm not law, but I'm like, hey, look here, where are you at with this? And what type of numbers? Why are you suing me? So, Your Honor, I'm saying that I believe this became more than what it should have been. It was a personal, I'm doing you a favor, you did me a favor. You charged the warranty company, you charged this, you got this amount of money, you paid me, I made my money, and now you need help and you went out of town. I'm watching over your truck and I'm helping you. Now you don't like the fact that, hey, look here, I haven't been in my truck, so I'm gonna sue you. I think this was just wrong for us to be here. I think that, you know, his truck is up and running. And honestly, when I learned about it, and I got the messages from the court, and I found out that we had court on Zoom, I showed up and I was here with you. I was here with Mr. Bunch. And I'm trying to find out where we're at here as far as they do, just come get your truck. Come get it out of my yard to where it doesn't get stolen. To where, you know, they don't come and steal the batteries out. They don't come steal the tires off of it. Just come get your truck. But he just keep letting it sit here. So that's my conclusion, Your Honor.
Thank you very much, sir. You get the last word on this much.
Ron, I submitted to the court copies of my bank statements. Last document. If you review those thoroughly, you will see how much money I was making each month leading up to Mr. Sim getting my vehicle. All I was seeking was the opportunity to continue to do that. That's it. I was working just fine until Mr. Sims, I believe, got upset because I would not just send the $7,500 with no question. And therefore, he took that out. He took the road that he's gonna punish. That's my belief. I can't look into it, but that's my belief. I didn't just send the $7,500, no question. But I was making, again, my bank statement fair. All I was trying to do is get back to doing what I was doing. And if Mr. Sim has ever given me an indication that I can come up to his shop, bring my brother or somebody with me, drive my vehicle and drive my truck, I would have been there on time, on task, and on mission to get my truck. But Mr. Sims never gave me that opportunity.
All right, thank you, sir. Thank you as well, Mr. Sims, for the proofs that are in on this case. And the court did not formally admit various documents and evidence, but the documents are not so significant, they're not in dispute. It's not disputed as to the time frame involved. It's not disputed that money was given to Mr. Sims before the departure, and that additional money was given subsequent to Mr. Bunch coming back. So this is not really a dispute about the contractual agreement between parties as relates to the repair of the vehicle itself. Whatever repairs were done, they were done in a manner that the parties have talked about here. That approximately $2,600 was tendered in August. Some work was done, additional $400+ was tendered subsequent to that time, and then some parts were brought for the repair of the vehicle. The issue in this case is, has to do with the surrender of the vehicle. That is the heartbeat of this case, and it's strange to me now as I begin to think about this and make a determination as to the outcome. In this case, I want to thank both of you for your presentation before the court. It's always refreshing to have individuals who are articulate, who are very clear of thought as they present their case before the court. Some people just are not able to do that either because of their education level or because they have poor communication skills. But none of that is the case with the parties here. Very, very articulate and able to communicate very well regarding the various positions in this matter. But all that being said, it doesn't make sense. I really don't get this, and I'm not saying that I don't get it from an intellectual standpoint, but just where this case is now between the two of you, it makes no sense. What I find in this matter is that the vehicle was submitted, whether on basis of friendship or people who have known each other casually or in a formal business setting. It doesn't really matter. The nature of this relationship is one in which a person, that is Mr. Sims, who has some expertise in repairing trucks of this nature, accepted the care and the concern of the truck during the period as a start where Mr. Bunch went on a trip. And during that period, he also made some repairs and to surrender the vehicle when Mr. Bunch returned home. Mr. Bunch returned, and Mr. Sims indicated to him that there were additional problems, and so the vehicle was not surrendered at that time. Testimony bears that Mr. Sims had his theory of the case, and that is that he felt that the estimate that involved some $7,000 was a way to make sure that the vehicle was sort of taken care of head to toe and back to front. Parties did not agree on that, but did agree further on some additional parts to be placed on the vehicle, and those parts were ultimately supplied. That's where everything breaks down. From that point, the notion here is that Mr. Sims is, for lack of a better way of putting it, dying to get this vehicle back to Mr. Bunch. Mr. Bunch is dying to get this vehicle from Mr. Sims, but for some reason you can't seem to make that what would appear to be a rather simple transition. It becomes the duty of the person who accepts a vehicle for repair, notwithstanding the issue of friendship. This was a neighborhood repairman, the guy in the alley that fixes a car and change the tire. The circumstances might be different. But this is a gentleman who has training that goes back to 1997 regarding the repair of these kinds of vehicles. He's an on-the-road repair person. He has great familiarity with trucks and how they are to be taken care of, diesels, etc. He has great familiarity with securing property that he has received that belongs to other people. That in particular, Mr. Sims, no question about that. he also has a duty that is born out of his knowledge, his work, and his commitment in respect to other people's property, to make sure that when work is completed on the vehicle, that the vehicle is surrendered. Now, there was a text that was sent in October that says work is complete, the vehicle can be picked up. That is an appropriate way of giving an indication that now you can come and pick up your vehicle. That's what a businessman does that understands that business and that takes on the duty to do repairs, whether it's a friend, a buddy, or straight up business. Either way, he has a duty to give notification that vehicle can be picked up. The testimony in this case is that anything but that over a series of several months discussions, attempts to get the vehicle, that Mr. Bunch has not been able to get the vehicle. The reality of it is that if Mr. Sims was taking it a step further in terms of what his duty is, he would have put something in writing and gave a particular and specific date by which the vehicle has to be retrieved or that other action would take place. There is nothing that is indicated in this record, either by way of testimony or any document presented to the court, that indicated that there was a specific date upon which Mr. Bunch would have to come into the vehicle and access would be made available to him to come and retrieve the vehicle. And so it was all left up in the air. That one of these days, somehow, in some circumstances, when it all works together for everybody, this vehicle can be picked up. You can't do it that way. You know, if it's me and Mr. Sims, I don't know anything about the vehicle, and I know the law on these things. I don't know anything about the vehicle. So if he's expecting me to tell him when he can come and get his vehicle, I don't know when he comes to get his vehicle, because I may be an expert in a whole bunch of stuff. I have no expertise in automobiles. I don't change tires. I'm not proud of that. I have a brother who was a mechanic. If you take me beyond putting the post on the battery and pouring some stuff on there to get rid of the corrosion, and you get me past that, then I'm a mechanic. That's about how rudimentary mine is. I probably would be a little bit better at some stuff if my brother was a mechanic, because he is. I made zero effort to figure any of that out. But Mr. Sims is an expert in this area. There's no question about it. The way that he articulates here on this record, the trust that Mr. Bunch put in him. Mr. Bunch is intelligent, he communicates real well. And while the parties have a dispute, one thing that's not disputed, Mr. Bunch believes that you can repair anything about this kind of vehicle. He's totally confident of that. Moreover, Mr. Sims has expressed great competence in making sure that the vehicle is repaired and taken care of. So in other words, Mr. Sims is not a guy that just picked up a trade. I don't know you, but just from the exchange that I've heard here, I think there are a lot of people that are fortunate that there's somebody who is diligent about analyzing and coming together with a project to repair vehicles that other people just look at and say, I don't want to put my hands on. So that's here. But with that comes the responsibility to say that I'm making this vehicle available to you on this particular date, and whether your schedule permits or not, you've got to be here on this particular date, this particular time to pick up this vehicle. And if you're not there, then I'm going to move it to the next stage, because as a agent of the state, a person who, by virtue of your license and qualifications to handle these vehicles, you can cause that vehicle to seize, you can cause a lien placed on the vehicle, all kinds of things. All kinds of duties come with that. The duty to put in some type of writing, some documentation that the vehicle is yours, you can pick it up on this particular date, at this particular time, and you have 30 days to pick it up, whatever. You got to do something. You got an affirmative duty to do that. Mr. Sims, and he did not do that in this case. That's the problem in this case. He did not do that. Now, there is a claim in this case for damages of $7,000. Actually, I guess it's good that it's here in one way and bad that it's here in another way. Because if this case is filed in a different setting and a different type of issue is raised, then this becomes a business interruption case. And you talk about amounts that's beyond the jurisdiction of this court. If Mr. Bunch could prove that immediately prior to the time that he submitted the vehicle to you, that he was making X number of dollars per week or per month, and so on and so forth, arguably, he could make a claim that from November at the latest, and from November up to the present time, there's been a substantial material interruption with his business. And then you would be responsible for the amount of that interruption for November, December, January through May, because that's where the damage area is in this case. That's not really been established on the record as to the exact damage amount, although there's been testimony that $3,000 was being made a month and so on and so forth. But that's not really been established on this record, and the claim is a $7,000 claim. If Mr. Bunch had brought this in circuit court, then a judge could likely consider whether or not $3,000 a month would apply, in which case you could potentially have November, December plus 5, so 7 times 3 is y'all figure it out, $30,000, whatever it is. So that's, and I hate to see this kind of thing among intelligent men that could mushroom and balloon into something along those lines. The second issue that is pertinent herein is that all of the time while Mr. Sims has the vehicle without surrendering the vehicle, he, from a legal standpoint, becomes responsible for whatever the condition of the vehicle is, deterioration, et cetera, which could mean additional dollars, the depreciation of the vehicle. All those kind of things become measures of damages. Now, those are not things that I'm considering. I'm saying that in another setting, all those things are on tape. And oh, by the way, the issue of storage fee. If Mr. Sims had given a notification regarding storage, and he could raise a counter action regarding storage fees, particularly for the period August through October. But so the two of you kind of got a big can of worms open on this, but it's easy for me to narrow it and kind of get at what needs to be gotten at here. But this turn could have, and maybe should have, people make decisions, turned into something much bigger than what it is here. Now, I say that to both of you, but I say that in particular to Mr. Sims, because both of you are intelligent, but you're much too intelligent to put yourself in this kind of position, because someone else who wants to nail you to the wall on this because of your skill and qualification and your duty that arises out of that, you end up in a situation where, sure enough, someone wants you to keep it as long as you can, because they can probably make an argument for $3,000 or $4,000 a month, and then if the judge say, well, I don't think it's that much. What if he says $1,500? What if he says $2,200? That's what it turns into. What if he says, now take the vehicle, get it assessed, and see if it has depreciated and all of that, and that becomes Mr. Sims' responsibility. That's what is at stake in this, in a different type of setting. So what you really come to here is that Mr. Sims did not take the action necessary to make sure that for the month of November 4th, that Mr. Bunch could come and get his vehicle without interference, interruption, that he had, that there was a notification that you got to come and get your vehicle. This is when you can come and get it. This is a set time. I know there were conversations on the phone and so on and so forth, but the duty to surrender that vehicle to Mr. Bunch, that duty rests on Mr. Sims. Just like with Mr. Bunch who bought the vehicle there, the duty to bring that vehicle there rested on Mr. Bunch, unless he had said, my vehicle is over here. I give you permission to send someone out to tow it to your place. But no, he brought it to you. That was his duty, to bring it to you. When it was ready, it was your duty to make sure that he had every opportunity to pick it up by giving him some kind of notification as to exactly when, where, and how he would be able to pick that vehicle up. And that was not done. That's a critical failure in this case. So my order in this matter is that the vehicle be surrendered to Mr. Bunch forthwith. That means right away. Moreover, should the vehicle not be surrendered by the month of June, on June the 1st, then the defendant will be required to pay $1,000 a month beginning in the month of June. So even if it's June 1st, if that vehicle has not been submitted and surrendered, June 1st is $1,000 a month. July is another $1,000. Now, as it relates to the months of November, December, January, February, March, and April and May that we're in now, we're in the hole. I'm going to cap the amount at $500 a month. So my judgment in this case will be that the vehicle must be surrendered forthwith, that the failure to surrender the vehicle for months of November, December, January, February, March, April, and May, that $500 a month is the court's set damages for the failure to surrender the vehicle during that period of time. That comes to, that's 7 months, that's $3,500. Judgment will be for the plaintiff in this matter in the amount of $3,500 plus the court filing fees, which looks like it's $86. Let's see, 86, 80, $93.50. Total judgment, $3,593.50, and the vehicle must be surrendered forthwith. Otherwise, additional damages apply beginning of the month of June. That is my order. And I will sign the judgment to receive a copy. Good day for both sides.
Thank you. Good luck, Your Honor. Thank you so much. So we catch you on the state side now, right?
Yeah, well, I'm state now, but the role that I'm moving to now, I will be the regional administrator for all of the courts in Wayne County. All of the judges, all of the courts in Wayne County. So it's a big responsibility, but that's something I'm looking forward to. It's going to be great. You know, I've been a judge 32 years, it's been 33